How many people are having fraudulent charges brought against them by police and then by the district attorney who knows they are false but proceed to prosecute innocent people anyway? Well, this is that situation, and I'm making this video to expose those people, to be a voice for those who are scared to go public or don't know what to do. Now, I was pulled over by a Clovis Police Department on August 24th, 2021 for no front license plate and tinted windows. I was telling the officer, Jocelyn Mahoney, how to do her job and explained if she didn't do it properly according to law, I would take her house. Let's just say that she was not having it. So Jocelyn tried to turn a simple no front license plate and tinted windows into a DUI. Now that's going to be another video because Jocelyn, Jason Gillis, and two other men that all work at Clovis Police Department took part in torturing me. Jocelyn held my hand behind my back while I was being stabbed with a needle for a forced blood draw. Anyone who has ever had their blood drawn knows you have to have your arm relaxed and in front of you. But I was stabbed more than 7 times with my arms behind my back. As you can see here, this is where they actually took the blood after I told them you can't take blood that way with my arm behind my back. And you can see the puncture wounds. It's quite a few. And I believe it was Jocelyn Mahoney who did it. And the chief of police, Kurt Fleming, and the records department to this day refuse to produce the body camera and building camera footage showing the torture. Needless to say, I actually beat the DUI and got the case dismissed on January 10th, 2023, and I was physically pushed out of the courtroom by a sheriff sergeant because I was exposing the fraud by district attorney and the judges. You can see here the case was dismissed. On August of 2023. Driving under the influence, resisting public or peace officer, driving without a valid driver's license, all dismissed. Okay, so we understand that I beat the DUI and the case was dismissed on January 10th, 2023. And on March 17th, 2024, 2 months later, I get pulled over by Clovis PD. And here's where the harassment starts. And I say this with certainty that the men and women working for Clovis PD did not like that I beat the DUI and are out to cause me harm as retaliation for beating the DUI when they should be holding those responsible who tortured me. Okay, on this day, Ramon Peinado pulled me over for no license plate and called dispatch to run my license plate. And the evidence given to me from the district attorney's office of the actual call with Ramon and dispatch was edited, covering up what was actually said to Ramon about my license. Now, Ramon in the body camera footage says what my license was suspended for, but that's not what Ramon cited me with. And in the police report, Ramon says that my license was suspended for, and what it was suspended for. And again, that's not what it was actually suspended for. So Ramon fabricated a charge. So let's take a look. See what the video here. Well, so why are you taking it down?
Different discretions.
I'm asking him because he's the one doing it, right? So what is the reason? Okay. Okay, you just heard there. It was suspended for refusing a chemical test. Him because he's the one doing it, right? So what is the reason? Okay. Not refusing, or for refusing a chemical test. That's refusing a breathalyzer. So let's take a look at actual police report. It says DMV license status check revealed that Martinez's driver's license was suspended due to failure to submit to a chemical test. Okay, so that's a chemical test. Now let's see what he actually charged me with. Driving while license suspended with prior DUI conviction, 1460128. Let's go see what that 1460128. A person shall not drive a motor vehicle at any time when that person's driving privilege is suspended or revoked for a conviction. Dismissed. Let's look at the date again. January 2023. When did he pull me over? Just a couple months after. So let's also see what the driving on suspended license for DUI consists of. It says 23152, conviction of 23152. 23152, it is unlawful for a person who is under the influence of any alcoholic beverage to drive a vehicle. So you had to be a conviction of this or a conviction of this that caused bodily injury to a person other than the driver, right? Those are the two convictions of violations. But we just saw that I don't have a conviction. Now let's find out about the audio.
Anyone, no plate. It's going to be a gray Infinity M35.
Copy, Will and Herndon.
3441. 10-8, NAC, NRF 21271.
10-4.
You see how it's edited? It's cut off after 29 seconds. Let's see what an actual dispatch should actually sound like.
5106. 27.
65106, go ahead.
106. We are on 180 East September. Boy 3082711.
65106, 180 to see September in, Sonnet 27 of Boy 3082711. 65106, 27 when you're ready.
65106.
65106, your 27 is returning suspended on a Class C to Los Martinez versus Gabriel, 72774 out of 5821 West Acacia, Fresno. Identifiers is going to be male, brown over brown, 61190. Suspended as of 9/23/21 for authority 13353. Refused chemical test. Negative FTAs.
65106 on that. Can I get a case number for 14601.2?
65106, requesting a case number for 14601.2.
Now, this is an incident where I was pulled over for highway patrol thinking that I was speeding. So that's exactly what the dispatch would have said from Clovis PD. But you heard how they altered it.
Herndon.
3.4 to 1. 10-8, NEC, NOS at 2.71.
10-1.
Now, we would have heard that the dispatch would have said that the license was suspended for refusing a breathalyzer. Now, the reason I say that they are acting with retaliation is that after my car got impounded, I went down to Clovis PD to speak with the chief, Kurt Fleming, and he refused to talk to me. And a man, Ireneo Guerra, who does at times act as lieutenant for Clovis PD, said that they believed the blood alcohol was accurate and refused to fix the charge that Raymond charged me with, and said that I should fix the false claim from Clovis PD that they charged me for the driving on for DUI with or refusing the breathalyzer with the Department of Motor Vehicles. The problem is that I won and beat the DUI, so Clovis PD is responsible for their actions, and they are the ones that are supposed to clear up their mistakes with the DMV. Now, I had another run-in with Clovis Police Department and was roughed up by a man, Dylan Soroka, who slammed me against the car, handcuffed me, and threatened me with kidnapping as he robbed my car with 4 other men present, and he fabricated a charge. Now, they're refusing to give me the body camera footage of that as well. That's subpoenaed, as well as the dispatch and the tow hearing, because they impounded my car and tried to impound it for 30 days for a fabricated charge. Now, Ramon sends the fabricated charge of driving on a suspended license for DUI conviction to the district attorney's office. And Matthew Hamilton, who does at times act as deputy district clerk or deputy district attorney, took it upon himself to also fabricate a charge. He fabricated a criminal complaint. He filed it to prosecute me. Now, understand this. Matthew has access to all the court records and to the DUI that I just beat 2 months prior. So Matthew knows there's no driving on a suspended license for a conviction of a DUI. Yet Matthew, knowingly with malice, proceeded to prosecute me fraudulently. Let's take a look at the complaint Matthew filed. So Matthew filed this on November 16th, 2021. Oh, wait, this is the actual complaint that was for the DUI. Now we showed it. We beat that one already. Okay, so here we go. Says on or about April 4th, 2023, in the above named judicial district, the crime of driving when privileged suspended for DUI conviction. So we understand it. There is no prior DUI conviction, right? So let's take a look at that again just to make it clear. There's January 10th, 2023. All the charges dismissed before trial. But Matthew still took it upon himself to file these charges. We're going to go over this deputy clerk thing right here in a second. Now let's see what the law declares is the criminal process. We call this due process. Actually, you know what? Let's see. This is the vehicle code. It's for refusing a breathalyzer. Refusing to submit a chemical breath test. That's a totally different charge. Okay, anyways. California Constitution. Section 8. Article 1, Declaration of Rights. No person shall be held to answer for a capital otherwise infamous crime except in cases of impeachment and in cases of militia, when the actual services and the land naval forces in time of war or which the state may keep with the consent of Congress in the time of peace, and in the case of petite larceny under the regulation of legislature, unless on presentment or an indictment of a grand jury. So we know here, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases of impeachment. Well, you can't impeach me. I don't work for government. So it has to be an indictment. And we just saw he filed a criminal complaint. And this is the Article 6 Judicial Department. The style of all process shall be the people of the state of California. All prosecution shall be conducted in the name and by the authority of the same. That's the people. That's you and me. Now, this is the latest Constitution. It says felony shall be prosecuted as provided by law. We just read the law. By indictment. It says either by indictment or after examination and commitment by a magistrate by information. So after examination and commitment by a magistrate, right? Now, this is the laws of the state of California, placed at the first session of the legislature. So this is how it all started, and this is how it still is. This is Chapter 2, Forms of an Indictment. It says, the first pleading on the part of the people is the indictment. It's not a complaint, it's an indictment. That's the first pleading on the part of the people. Let's go on. Now it's Chapter 119, an act to regulate proceedings in criminal cases, page 275. It says every public offense must be prosecuted by indictment except where proceedings are had for the removal of civil officers of the state. Right? That's what the Constitution said. No person shall be held to answer for a capital or otherwise infamous crime except in cases of impeachment, right? So that's every public offense must be prosecuted by indictment except where proceedings are had for the removal of civil officers. Okay, so then that's when they file a complaint. It says a criminal action is prosecuted in the name of the people of the state of California as a party. So again, we read that the people of the state of California have to be a party. And the woman that took over the case for Matthew, her name is Bethany Samarin, and she confessed in open court that there are no people that are a party or that she is prosecuting on behalf of. So she confessed to overthrowing our form of government, and she's causing harm to the people by using fraudulent complaints in the people's name. That's literally warring against the people, and that's treason. Okay, so let's just say that they were allowed to use a complaint against the people in the private. Here would be a procedure because it's the same for them. And information, which is the complaint, may be laid before any of the magistrates mentioned in section 104. It says, when the information is laid before a magistrate, he shall examine on oath the complainant and any witnesses he may produce, and shall take their depositions in writing and cause them to be subscribed by the parties making them. Subscribed is sworn. Subscribed and sworn to before me. She's claiming to be a deputy clerk, but she's actually an office assistant. Personally appeared before me, who first being duly sworn. That's kind of down because it says e-file, so nobody personally appeared before anybody. But it says right here, when the information is laid before the magistrate, he shall examine on oath the complainant. Who's the complainant? Matthew Hamilton, and cause them to subscribe by the parties making them. So the magistrate is supposed to have them swear under oath to what they're saying, but that didn't happen. Okay, let's read what this is here. It says, an accusation in writing against any county or township officer for willful or corrupt misconduct in office may be presented to the judge of the district court of the district within which is the county or for which the officer accused is elected or appointed. The accusation shall state the offense charged in ordinary and concise language without repetition, right? So we can all understand what they're saying. And in such manner as to enable a person of common understanding to know what is intended, and shall be verified by oath of the person making the same, to the effect that he believes the charges therein contained to be true. Okay, so the person making the complaint has to swear before the magistrate under oath to what they're claiming is true. It says, after receiving the accusation, the judge to whom it is delivered shall forthwith cause it to be transmitted to the district attorney of the district, who shall cause a copy thereof to be served upon the defendant, and require by notice in writing of not less than 10 days that he appeared before the court. Hold on. Matthew Hamilton is the complainant. He's the one accusing. And it says the accusation, after receiving the accusation, the judge to whom it is delivered, that's the magistrate, shall forthwith cause it to be transmitted to the district attorney. Matthew Hamilton is the district attorney. Do you see why it's supposed to be an indictment? That complaint is supposed to be from somebody else, one of the people complaining that somebody did something wrong. And then it goes to the district attorney. Do you see how it's fraudulent? That complaint is fraudulent because Matthew Hamilton is the district attorney. How can he be complaining, saying I did something when he had no personal knowledge? Okay, it says, of the information and proceedings thereon to the commitment inclusive. Chapter 1, the information. That's the complaint. The information or complaint is the allegation made to a magistrate. Again, made to a magistrate. That's a deputy clerk. This is the complaint, which is information, which is not a deputy clerk because she's an office assistant, and we'll go over that in a little bit. But it says subscribed and sworn to before me, which they didn't, because these women right here literally told me that they've never sworn anybody in, that they don't have the authority to swear anybody in. That's literally fraud. They just sign it as they receive it, showing that they are office assistants. They're not actually deputy clerks with the authority to swear anybody in, because otherwise they would know that they're swearing somebody in. Okay, it says a magistrate is an officer having power to issue a warrant for the arrest of a person charged with a public offense. The following persons are magistrates. That's the judges. When an information is laid before a magistrate of the commission of a public offense triable within the county, he must examine on oath the informant or prosecutor. Right? It doesn't say that the district attorney is the informant or the prosecutor, whoever's making the complaint. But the district attorney made that complaint that I just showed you. Right? But he didn't swear under oath to it. But the magistrate must examine on oath. We just saw subscribed and sworn to, but they didn't, but it says it, right? Making that fraud still. And it's produce and take their depositions in writing and cause them to be subscribed by the parties making them. So the magistrate is supposed to get the complaint from them, right? From the complainant and any witnesses, and put it in writing and cause them to swear. The deposition must set forth the facts stated by the prosecutor and his witnesses, tending to establish the commission of the offense and the guilt of the defendant. Nowhere does it say take it before a deputy clerk. So let's see what it says about deputy clerks. Each county clerk shall take the oath of office and give bond to the state of California in the form prescribed. Each county clerk may appoint one or more deputies, who shall have the same power and respect as their principal. The appointed shall be in writing and signed by the county clerk, and shall be filed in the office of the recorder of the county. Now, I did a public records request on these people, and they don't have any oaths of office or any bonds for them because they're not court clerks. Now, the woman that signed the complaint as a deputy clerk is not a deputy clerk. She's an office assistant. She never took an oath of office as required to be a deputy clerk, and no one personally appeared before the deputy clerk swearing to this document as it reads. Making it even more of a fraudulent document. And the office assistants are even signing subpoenas when those are supposed to be signed by the clerks. Let's take a look at that. Name and title, OA's Office Assistant 3. Here was a subpoena that was for October 2nd to Clovis Police Department, and they just ignored it. As you can see, it's got the court seal, but it's signed by an office assistant. Now let's see an office assistant right here. OA3. 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 Now that's definitely different than a court clerk, which is a judicial assistant. I did a whole video on the complaint and how it's a fraud, and I put the link to that in the description. There's another thing on the complaint. All of which is contrary to the form, force, and effect of the statute. Now, this vehicle code is a public statute. Oh, actually, I wanted to show you that a subpoena has to be signed by the clerk of the court. Amador Superior Court. And here's a civil one. Also, different counties, so you can see that it's the same process. Clerk of the court, signature, name, court seal. As I was talking about the statutes, it says statutes are public or private. A private statute is one that concerns only certain designated individuals and affects only their private rights. All other statutes are public, in which are included statutes creating or affecting corporations. We're not corporations. Now let's see who corporations are. This is New Hampshire HB 1778. It's a good read. It's a bill that didn't pass, but it's the facts that are in this that are important. It's about driver's licenses and registering your car. And the bill didn't pass. I have no idea what happened there. They were going to make the Department of Motor Vehicles pay for licenses or IDs for the people in the private, so they didn't have to register their car and they didn't have to have a driver's license because drivers are commercial drivers. And it explains that in here. It's a really, really good read, and it's all facts. And the bill didn't pass, of course, but that just means that the bill didn't pass. But if you look here, it says the Senate and the House of Representatives in general court convened, right? So this is the important part. The general court finds, it's findings of a court. That's the legislature. They have these findings, right? So it's a really good read. It says the general court finds that the authority of the Department of Safety, which is the Department of Motor Vehicles, is limited to only commercial users of the public ways and the corporate state employees. That's public servants. That's corporation. That's the government. Have by their silence failed to fully inform the sovereign people of this state that an automobile has been confirmed by Chief Justice Grimes in 108 New Hampshire 386 to be private property defined by current RSA 382A9109 as household goods and consumer goods, not for commercial use or for profit or gain. Okay, this is really important. Further, the courts have found that the corporate public servants who ignore their accountability as mandated in Article 8 of the New Hampshire Bills of Rights have by their silence and failure to fully inform the sovereign people of the consequences arising from the corporate offer to contract is deemed silent deception and inducement by fraud. Now that's talking about every government employee or every judge, every police officer, every district attorney, everybody who works for the government that's not telling you the truth. It's not being transparent. They are being in the act of silent deception and inducement by fraud. Okay, so the justice system in Fresno County is one of the most corrupt organizations in California. Our Constitution lays out the duties and responsibilities of government employees. That's our form of government. It literally puts the police, district attorney, and judges in a box and declares what they are allowed to do and the things they are required to do to secure our rights, and they are literally ignoring the very Constitution that they swore to uphold. That's a breach of contract because they all took an oath to support the Constitution. It is the mandatory contract to work for us. Now, let me be clear. Most of them have no idea what they swore to uphold because they were trained to uphold statutes and codes. And that only applies to government, to corporations. And that's who they are. They are corporate public servants, as you just heard at what I read in the New Hampshire legislature. The definition of internal insurrection is overthrowing the form of government and warring against the people they serve. And so the Constitution lays out our form of government, that they all swore that they would uphold it. But they are not upholding it. They are overthrowing it to make money off of you and me. The police, the sheriff, district attorney, judges all have knowledge of the Constitution they swore to uphold, and some don't understand it and probably don't care to understand it. But they all swore to uphold it. And so when they lie or don't honor the oath they took, that's a breach of contract. And they all lose their immunity because they are acting outside of their box and are liable to be prosecuted as a man or a woman. And that means you can sue them for everything they own, and they are subject to criminal prosecution. Let me be clear. Every judge, court commissioner, and district attorney and attorneys know they have to follow strict procedures called due process. And when they are dealing with the people in the private, that's you and me, that we are not government employees or registered to do business as corporations, that they have to follow strict guidelines, right? That's an indictment, and not step out of their box. They also have to have one of the people as a party to the prosecution they're bringing against you. Now, the people are either the grand jury or someone that was actually harmed. It's all about money at your expense. If they don't have a constant caseload, they can't make the amount of money that they make. Let's be clear. They are supposed to protect you and me from fraudulent claims and process by the district attorneys, but they don't, because they're all working together to cause us harm with fraudulent court process so they can have the huge caseload. That's causing us harm, all to make a profit off of us. And that's the definition of internal insurrection. It's overthrowing our form of government and warring against the people. And that's literally treason. And every judge in this case against me has also trespassed. They all know what they're doing. I keep bringing it to their attention. They don't care. They're trying to protect the district attorney. When you just seen the fraudulent claim that the police officer brought against me, then you see how the district attorney, knowing that there's no DUI, also brought a fraudulent charge against me using a fraudulent complaint. Distinction between constitutions and statutes. 16. American jurisprudence. 2D. Constitutional law. Subsection 2. Notice this is May 2025 update from American jurisprudence. It says the Constitution is the framework of the government containing the general principles upon which the government must function. A state constitution receives its force from the express will of the people. Statutes, by contrast, are enactments and rules for the government. All other statutes are public, in which are included statutes creating or affecting corporations. Statutes, by contrast, are enactments and rules for the government. As an expression of the will of the people, a state constitution stands above legislative or judge-made law. There's no such thing as judge-made law. That's the case law, what they call it. But the legislator makes the law. You get that, right? Okay, so there's no judge-made law. Where a constitution speaks plainly on a particular matter, right? It said in the Constitution that it must be an indictment, not a complaint or information. So it must be given force and effect as the paramount law. And where a statute or other rule and constitutional provision are in conflict, the constitutional provision must prevail. That means the Constitution says that there's an indictment, so it's got to be an indictment against the people, not a complaint. The complaint is for the people that work in government or corporations, which we are neither.